Okay, we are officially in silly season about the election and the election of someone who, in the majority opinion in the United States, is totally unfit, despotic, tyrannical, any other corrupt individual for president in the United States, which should be a red flag or some kind of a wake-up call to the fallacy of what our political system and how it's assembled has become. Because it boggles the mind that we could elect any person, even a Hitler or worse, in the United States, and think that we had to follow them and let them do whatever they wanted while they were in office. Whether we agree with it or not. And the only way that we could fix it would be in 4 years when we have another election. Or like they tried during Trump's first term in office, after the midterms, they tried to impeach him. And they didn't even know how to do that process right. So he didn't even show up at the trial in the Senate. They didn't know that they're supposed to remove them from office as soon as they are impeached until the Senate can consider the impeachment to determine whether that person returns to office or whether they are booted out upon conviction, and if it's for a bad enough offense, then they would be remanded over to the criminal justice system to face criminal charges and criminal penalties in the normal course of law. So no, the Senate is not a court of law. It's a HR move. To remove the person, that is malfeasant from being able to do anything else. And that raises a serious question, especially with all this craziness they're talking about with Trump using the military no. The Trump does not direct the military. The president doesn't determine what the military does. The commander-in-chief reports to the states as they are assembled in Congress as the union. And the union makes the decisions on what to do. Now, yes, if the president is a strategist and can understand how to no. They still only manage the operation of the government. They don't actually participate in the decisions or in the execution. Whereas, yes, Washington was the commander with general on the field, like Eisenhower, or something, was when he was commander of the forces. But that's not the role of the commander-in-chief today, or even when they did it back then, because even then, when Washington was the commander-in-chief under the Articles of Confederation, it wasn't like he was going to get out there on a horse and fight nobody's battles. And even then, he would still have to report and get direction from the states as the union. And if they didn't like what he was doing, they would fire him and they would get somebody else to do it. They're not stuck with the commander-in-chief that they chose. They might have made the wrong choice. They can get rid of him when they feel like it. Anytime they feel like it. And that's the same for every civil officer that we have in the United States today. The states as the union don't have to keep any of them for any reason. Anywhere throughout the government, even for civil officers that they deem can be appointed without their advice and consent. If they don't like that person or how that person is doing their job, no, the states can immediately remove them from office by impeaching them. And there's nothing anybody can do about it. Nothing. Okay, so this goes back to, what is Congress? and what is the union? Because the union is the states, okay, assembled as a democracy. Where? In a Congress. Okay? The United States in Congress assembled. That's where the states are assembled as the union. Okay? So there's a question now. Because do we have to, or do the states have to even consider the election results? Okay? Do they even have to consider them? No, they don't. And in fact, the fallacy of the whole thing is, of what we've done is, if the states wanted to, they could inaugurate him and immediately impeach him almost simultaneously. So while he's taking the oath of office, as soon as he says "I do," they can, the 9 largest states in the United States have enough proportional suffrage in the House to impeach anybody. 9 states. And even if Texas and Florida decided that they didn't want to impeach him, the other states, it would just take a few more states, but those states that consider themselves blue states on their own could impeach the president. And there's nothing Trump, the Republicans, or the Supreme Court could do to stop him. Because they're the states as the union. They're the highest power, the established government authority. They're the highest power. So they could simultaneously impeach him. And that would remove him from office while the Senate, the states in the Senate, considered his impeachment. Okay? So he could never actually put a toe in the office if they didn't want him to. Okay? So that begs the question of why wait till then? Well, you don't have to. In fact, one person has the power to throw a wrench in this whole mess, and that is Kamala Harris. because she is the president of the Senate. And she has all the power and authority to throw out all this mess. She doesn't even have to accept the certificates when they are transmitted to the Senate to her attention. It says that they would certify the list, seal the list, and transmit the list to the seat of government, directed to who? The president of the Senate. Okay? So when Kamala Harris gets those certificates, she doesn't even have to accept them at all if they aren't properly made. The list don't meet the requirements of the number of electors, when the electors were chosen, the time of choosing, the day they gave their votes, that the votes were not distinct votes, that the lists were not distinct lists of all persons receiving votes, the number of votes, and the office for which those votes were intended. And that's in her opinion alone, because she's the vice president, the president of the Senate. And there's no higher authority, not even the Supreme Court, could tell her that she had to accept the certificates from that election. Nobody. And then, if she was too stupid to know what her role is as the vice president and how she's empowered to act to ensure the proper assembly and functioning of our government, the states could, right then and there, if they don't have, because what the electors are doing is the electors are forming a list of choices that the states must consider for those positions. So the electors don't make the choice. The states make the choice. The only reason why they put in that business about if a person receives a majority of the electors, of all the electors, then that person will be, is because that's the will of the people. That's a majority of all the people, because it's a majority of all the electors. But they never expected that to ever happen. And in fact, it's almost impossible today for any person to receive to be identified by a majority of the electors. Number one, there are too dang many electors, because there's supposed to be 11,121 electors, which is the whole number of representatives that does not exceed one representative for every 30,000 persons, which resides in each state based on the 2020 census. And that's calculated by a proportionality constant. So there's no way that you can come up with any other number than that 11,121 electors. We have no choice in that matter whatsoever, because that has not been amended in the Constitution. Okay? And that is the number that the states may be entitled in the Congress. Okay? Not the number that they're given unconstitutionally. Okay? The number they may be entitled. And that number is 1 for 30,000. Okay? So, if they don't have that list, then the states can't make a choice, because what happens is they don't look at all those people who got votes. In the first election, there were 12 different people who received votes of the electors. 12. 12. Only 10 states participated. They had 12 people who received votes. In fact, the state of Georgia, with 5 electors, chose 5 different people. Okay? But when it gets to Congress, what they do is they only take the top 5, if you just go on the Article 2, Section 1, which we should do, because the 12th Amendment is kind of, it's just wrong. But under the 12th Amendment, they would take the top 3 for for president and top 2 on the list for vice president to form what? A ballot that of names that of persons that the states must consider to determine their choice. So the people determine the choices, the states determine the choice. Okay? And the choice must be made by a majority of all the states to become president and vice president. Okay? So if they don't have that damn list, the states don't have to consider those things at all. And they could immediately determine a time for appointing electors and a day on which they must give their votes, a day which must be the same throughout the United States, which could be, January 7th. Okay? They can say at 9 o'clock in the morning on January 7th, the states will choose their electors. Later that day, at noon, the electors will gather to give their votes and make their lists. And that those lists have to be transmitted to the seat of government by 5 p.m. the evening of January 7th, 2025. And then they could open those lists in Congress on January 8th, 2025. And determine if anyone received the number of votes they needed in order for either person to become president or vice president. And if no person received that majority, then they could immediately form those ballots of 3 and 2, 1 vote per state, to choose from those 3 persons, and a majority of all the states would be necessary to the choice. And after making their choice by majority consensus, on that same day, on the 8th, they can inform the person who becomes president and vice president that they have become president and vice president, and then they can inaugurate them the next morning on the 9th, and they can begin their term of office. And if you wonder where I got this from, it comes straight out of the Journal of the Senate, the first 100 years, for how they determined that Washington was the president and that Adams was the vice president, and they had to send out a messenger after they determined who had become president, vice president, to inform Washington and Adams of their selection and the time on which they would take office. Okay. And there's nothing the Democrats, Republicans, or even the Supreme Court could do to stop the states from doing whatever they want, as long as they do it how? Together as the union by a majority consensus. Why? Because they are the established government authority. Not the president, not the Supreme Court. Supreme Court can only take up matters that Congress brings to them. They can't take up matters that come from anywhere else other than from Congress. All petitions for redress have to go through Congress to get to the federal court system, the Supreme or inferior courts. It all has to come through Congress. So there's no higher authority in this country than the states as the union assembled in Congress. Okay? And there's nothing any of those other people, I don't care what they want, they can't even fight what the states as the union want to do. And see, people don't even understand that why we have the Bill of Rights. We have the Bill of Rights because that's a lot of power. Because it's not just one powerful person who's only powerful because he might have a military behind him or something like that. No. This is collective power. And if they direct that collective power anywhere they want, they can do whatever they want. And there's nothing nobody can say to them. The Supreme Court can't tell Congress nothing that they have to do. Nothing. Okay? Now, the states do have a conflict and dispute resolution clause, and they can file grievances for redress when laws disadvantage them disproportionately or disenfranchise them in any way. Laws that are properly made in a properly assembled legislative institution, and the states have agreed to abide by those decisions. But they also have to agree on the court, how the composition of the court, who makes the decision. The states have to agree. And if the states can't agree, then they have a process for how to assemble the Supreme Court in a consensus, by a consensus choice, and draw out names by lot in order to where they know that the decision is being made by an independent body, and then because the states wouldn't agree to abide by the decisions of the court if they couldn't have couldn't be assured that the court was impartial. And that's why every state has to have one of their own judges in the pool of judges that can be drawn out by lot. And then they only draw out 5, starting with the petitioner. Okay? To hear and decide the court, the thing in the Supreme Court. And today, because the justices are continually seated, that number has to be 50. Okay? Now, Congress can reduce that number to no less than, because 50 is a lot. And they can reduce the number to no less than a simple majority of the states, which would be 26, and no more than 2/3 of the states, which is 34. So they could, reduce the number by a third or so, or more, or even by half before the names are drawn out by lot. Okay. And they can determine how to do that in Congress in order to reduce the list. But no, you can't have a Supreme Court that has a, tilt towards party or ideology or political affiliation, or no. The states don't have to abide by those decisions. So if nothing else, this whole mess right now should be a teaching moment for us. Because not only do we have to understand what we're doing wrong, we need to understand how to do it right and why, to protect us from being subjected to tyrants and miscreants and, people who, like Hitler. No, we don't have to get in line behind Hitler because he won a popular election in the Electoral College. No. And we don't have to for Trump either. And you hear some of these people like Al Sharpton is going to have a rally for MLK on the same day as the inauguration. What the heck is he trying to do? What does that mean even? What's it supposed to do? Is that supposed to be some kind of a solution or a way to fight against Trump and what Trump might do when he becomes president? An office where the president does not do anything. The president only oversees the executive departments to take care that the laws are faithfully executed. Okay? He doesn't actually execute the laws. He only makes sure that the executive department that is supposed to be executing those laws is operating properly, doing it properly. And if they aren't doing it properly, what does the president have to do? Transmit that information to where? Congress, for their consideration. So if the executive department isn't functioning properly, the president tells Congress, Congress calls in that department principal officer and tells them exactly how they want them to do the damn job. Okay? It's the established government authority. There's a reason that the Assembly of the States is the established government authority, and why Congress is a democracy, where all the states are assembled as equals with equal suffrage to reach a majority consensus to make all the decisions of our government. That's enough for now. Thank you.